Okay, we'll go ahead and get started. Thank you all so much for joining. My name is Tim Seidman. I'm the labor and employment attorney for VirgilHR. I have been a labor and employment attorney for about a decade now, and we're excited that you're all here to review some summer compliance updates. It might be the summer doldrums for some, but not for us in the labor and employment law compliance world. Very much the opposite. All right, so we'll get on to it with the next slide here. All right, so just a quick bit about VirgilHR. We are a tool that can help automate complex and frankly often monotonous processes that HR professionals are often burdened with. And we do this through a variety of tools that you can use on our platform, including a multi-state comparison tool, a feature where you can ask an attorney, labor and employment law related question, contact an expert. We have a chatbot with a whole host of labor and employment laws built into it that you can utilize, and employee handbook builder, and so much more. And I want to also quickly shout out OneSource Virtual, our great partner here. They help empower HR and finance teams by automating those complex back office operations. To learn more about OneSource Virtual, you can visit their website, which you can see on the slide here, simply onesourcevirtual.com. And a quick disclaimer, I cannot legally provide legal advice in a forum such as this. So this slide is just explaining that. This is not legal advice. If you have any legal questions concerning any of the topics that we touch on today, we suggest that you reach out to an experienced attorney. Okay, so summer 2025 employment and labor laws. We're going to touch on a few different topics here. We're going to go through pay transparency, non-compete agreements, minimum wage laws, or minimum wage changes, sort of a smattering of different labor laws that are all taking effect sometime this summer, some as soon as the 1st of July. We'll be hitting on a number of different states. If you don't see one of the states that you have covered employees in, don't worry, because a lot of these topics are indicative of various labor and seen over the last several years. So it could be the case that a law in one state will soon be popping up in a state that you have employees covered in. All right, we're going to start with pay equity and pay transparency. So pay transparency is a topic that's really emerged as a growing trend in labor and employment law, with many states enacting laws that require employers to disclose wage ranges in job postings and for applicants as well. The idea behind these laws is to promote pay equity and reduce discrimination in pay practices. And so we see here that Vermont is one of these states that has a new transparency law coming out shortly, where employers are going to be required to include the expected compensation or range of compensation in their job advertisements. So this will apply to employers that have at least 5 employees, at least one of whom works in the state of Vermont. So not all 5 employees have to be in Vermont, but at least one of them does. It applies to advertisements that are either for job openings that are either physically located in Vermont or a remote job that calls for work that is predominantly performed in the state. So keep in mind that this could, come into play obviously during the recruitment process, but also for promotional opportunities for existing employees as well. And we will move on here to Washington. This is more of a pay equity law as opposed to pay transparency. So we're probably all aware of the Federal Equal Pay Act, which we know prohibits discrimination in pay based on an employee's sex. It's important to remember for this law, as well as several other laws that we'll be touching on during this webinar, that generally speaking, federal law sets the baseline of compliance for employers. And states usually have the authority to enact their own laws that can provide greater protections for employers or for employees. Washington is one of those states here that has their own equal pay laws. Washington's equal pay law used to basically mirror the federal law in that it prohibited discrimination in pay based on gender, but it's now expanding to include prohibitions in pay based on all of the protected classes under the state's anti-discrimination law. So that can include age, sex, marital status, sexual orientation, and all the other protected classes that you see included here on the slide. And next, move into the world of non-compete agreements. The current trend for non-competes the FT non-competes. That was ultimately blocked by the judge in August of 2024. We can expect the current administration to be more hands-off when it comes to sweeping rulemaking concerning non-competes. So that leaves room at the state level, as we will see here with a few different states, I believe starting with Indiana. So regarding physicians in general, we see a bit of a nationwide trend in favor of physician mobility. So it could be the case that certain states pass prohibitions on non-compete agreements in employment contracts that aren't that don't limit non-competes for all employees, but just for certain professional employees, such as attorneys, and in this case, in Indiana, for physicians. Indiana's ban is actually part of a patchwork, I suppose, of physician non-compete bans that already exist in the state. This new ban is specific to hospitals, meaning it invalidates non-competes between physicians and their hospitals. And that could include the affiliated manager of a hospital or a hospital system. And we'll move on to Virginia, which is another, it's not an all-inclusive ban on non-competes, but it's more specific than that. So under current law, there's a ban on non-competes for low-wage, quote-unquote, so-called low-wage employees, and that meaning an employee who earns less than the average weekly wage in Virginia. Now, there's a new amendment to this law that expands the definition of what low wage means. So it now includes employees who are all employees who are classified as non-exempt under the FLSA, with maybe a few exceptions. So Virginia employers consider auditing your workforce to ensure that all exempt employees are correctly classified in anticipation for this July 1 ban. And we have one more here. This is more of an all-encompassing ban. So maybe a bit of a surprise to some, but we see Wyoming entering into the fray here. Wyoming is joining a growing number of states that have passed these all-inclusive bans, like California, Minnesota, North Dakota, Oklahoma, to name a few. So these are sort of general use bans. We see that there is specific language for physicians in this law as well. It restricts non-competes between, quote unquote, between physicians. So it appears that non-competes involving physicians and their hospitals might still be okay. A bit of a murky area under this new ban. This applies prospectively, so it does not void existing non-competes. So For Wyoming and the rest of the states that we just mentioned, employers should consider revising their current restrictive covenant agreements that they might sort of blankly provide employees to make sure that the various types of non-competes are not included in those anymore if they are banned by these new laws and amendments. Okay, July 1 means new increased minimum wage for a certain group, certain number of states and localities. So we can we wanted to highlight a few. We won't cover all of them here, but let's get into the first few. I believe California is likely up first here. Yes, we see a few places where new minimum wage laws are going into effect. A lot of states that have their own minimum wage laws either see increases on the first of the year or in the middle of the year here on July 1st. Okay, so DC is up first. So it'll be jumping from $17.50 an hour to $17.95, and that'll be for all workers regardless of the employer size. California is one of those places where there are a whole bunch of localities that have their own minimum wage laws. A very good resource to check out for the California locality minimum wage laws is UC Berkeley, which hosts links to all of these localities' minimum wage websites and lists the specific increases that are going into effect. So here's sort of a smattering on the right side here of different counties that are seeing new minimum wage increases for July 1st. Oregon is an example of a state that has it has several different minimum wage requirements, not as many as California, not as few as those states that only have a statewide minimum wage rate, and certainly not as few as those states that have no set minimum wage and just follow federal law. Oregon has three different rates here depending on where you live. The standard rate is going up from $14.70 to $15.05. In non-urban counties, it's increasing to $14.05. In Portland is special, so it gets its own wage of set $16.30. For our Maryland employers, Montgomery County is seeing an increase. This is an example of a locality where the minimum wage depends on the size of the employer. The large employers generally are required to provide a higher minimum wage. As we see here, for those employers with 51 plus employees, will go up to $17.65, and a little bit less for those mid-sized and small employers. Okay, we've reached the portion of the webinar where we will discuss a sort of grab bag of different labor laws taking effect this summer. New Hampshire is up first. They've passed protections for nursing mothers. So employers are required to develop policies to address the provision of sufficient space, and two, reasonable break periods for nursing employees that need to express milk during working hours. For the spaces that need to be provided, there are various rules. The location must be within a reasonable walk of the employee's work site. It can't be a bathroom. It must be a clean space, shielded from public view. Reasonable break period, that's defined as an unpaid break of approximately 30 minutes for every 3 hours of work performed by that nursing employee. Important to note that expression of milk does not include breastfeeding. And also to note, there's a hardship exemption for employers, as we see from time to time when we look at different accommodation requirements. If providing that reasonable break time and sufficient space would impose an undue hardship on the employer, there's an exemption there. Okay, Ohio is moving into the 21st century. Digital workplace postings. Some states postings simultaneous with the requirement of having to continue to post them physically in the office. Ohio is saying you can do this in lieu of the physical posting in the workplace. And this is for a variety of required workplace posters like the Ohio's minimum labor law, minimum wage labor law, Ohio's minimum fair wage standards law, the civil rights law, the prevailing wage law. Employers can still choose if they'd prefer to post them physically, but it's nice to see a digital option. Okay, so again, this is another example of, I'm sure we're all aware of the federal WARN Act, which requires employers with 100 or more employees to provide 60-day advance written notice ahead of plant closings and mass layoffs or RIFs. So this is another example of a state setting a more protective regulation for employees. So it'll require all employers with only 50 employees or more to provide such notices. Employers will need to provide those notices to the state, any relevant union, and the affected employees. So we've included some for employers, top summer business risks. I like this slide because you may hear from time to time from an employer that what you've explained regarding labor and employment, any applicable labor and employment law is interesting, but why should I care? And it's nice to be able to show them, you will be penalized up to $10,000 if you violate this new pay transparency requirement, for example. Money talks, and so this can be helpful in sort of advancing the cause of many HR professionals here. We suggest an employee handbook refresh. Generally, employers do this on an annual basis or so, and as new requirements come in during the year. We have a few essential updates here, things identifying outdated policies, flagging as a few key sections to keep in mind. See, areas where you might see a bunch of changes occurring during the year based on some trends discussed today, such as a non-compete or layoff, changes to state law. States are always changing their leave policies, certain states more than others. Data privacy, AI usage is another emerging trend that we haven't got into today, but certainly something to keep an eye on as more states continue to regulate that. I believe New Jersey has passed regulations around AI, I think New York City, various other places. Okay, and we will be taking questions. We will be taking your questions, and I think we'd like to continue moving through the slides here. Okay, this is where you can, if you've liked what you've heard, And if you're interested in the VirgilHR tool, please scan this QR code to schedule a demo. You also see the SHRM activity code here for your PDC. And okay, we can see if we have any questions. All right, so it looks like there is a question about minimum wage. Let's see here. Has there been an increase to the, I think this question is about whether there's been an increase to the federal minimum wage. So the federal minimum wage is $7.25 an hour. We saw the Biden administration attempt to increase that, but it's currently at $7.25. There is always legislation banning about to let's say double that to $15 an hour. I think there is currently right now legislation introduced in the Senate looking for that increase, but we haven't seen it go into effect. Not just yet. There's a question about remote employees. For remote employees, I think the question is, which labor and employment compliance laws should I apply to those employees who are working remotely? And so generally speaking, the labor and employment law that applies will be that of wherever your employee is working from, as opposed to the residence necessarily. So the state and locality where they are performing their work is where you want to look. Okay. EEOC harassment training is something, yeah, that's something I believe that's strongly recommended by the EEOC, not necessarily required. Certain states certainly require sexual harassment training, both for supervisors and for employees on an annual or sometimes semi-annual basis. So that's another area that states can have their own say in. Yes, we will be sending out a copy of this presentation, I believe, next week. We have a question on non-competes, conflicting non-compete laws. So if you're operating in multiple states, again, you'll want to look at where that employee is situated and apply the non-compete law that applies in that location. Do I go off the number of employees per state or overall employee headcount? That depends on the law itself. So you'll want to look at the statute or the regulation. and it'll oftentimes tell you. So for example, in Vermont, um, the the law that we discussed today is effective for it says actually this is only explained in the guidance that the state have provided after the fact. So sometimes you'll have to do a little bit of digging into the regulations or into the state's various states Department of Labor guidance provided on a statute that might be a bit vague on that question. Um, uh, but often, I'd say more often, as long as you have an employee in that state, usually if there's an employee threshold, it's dependent on total employees, not necessarily the total number of employees that you employ in that state. Um, if it specifies that it's based on the employees in that state, then obviously that's the case. You might also have to look up the definition of employee um, that applies to that particular statute or regulation to find out. Um, Again, for remote employees, it's less important on where the company's HQ'd at versus where that employee is situated in most circumstances. Has the salary threshold for EAP employees for exemptions under the FLSA change? No. Briefly, there was a change, but that was overturned. How soon do I need to update my handbook? So you'll want to update in advance of the law going into it. Um, as much advance notice as possible. I think best practice is to get an of the change in their handbook as well. So um, enough advance notice for that as well. Um, Pay transparency violations can, yeah. So those can accumulate. There are a lot of penalty provisions in various statutes and regulations in this area of the law. Bit of a pass, a bit of a slap on the wrist for your first violation. Maybe it's 100, maybe it's a stern warning, and then those can start to progressively increase the worse of an employer that you are for continuing to violate that law. Notifying employees in writing about any changes is certainly a best practice. Certain statutes and regulations require that, so you'll want to look at the language of the law itself. How are enforcement agencies monitoring compliance with these laws? Employees, effective employees and prospective employees are complaining to the various states' departments of labor, or OSHA comes in, takes a look around, sees what's happening, or they monitor for in the instance of pay transparency, they can just monitor your job advertisements that you post online. see. What are the consequences if I don't comply with these laws or realize I was wrong after the fact? Certain laws have provisions where you can cure your violation if you act within a certain time period. If you sort of within a certain time period after being made aware of your violation, if it was something you didn't realize you were wrong. For Vermont pay transparency requiring salary ranges and job postings, how wide can those ranges be before they start becoming meaningless? So you want to give a good faith estimate is what a lot of these pay transparency laws require um, if you're not set on a specific number. So, good faith. Um, good faith can mean different things, but you want to kind of be in the ballpark there. Are there any pending court cases or regulatory guidance that could significantly change how these new laws are interpreted? Certainly that could be the case. I'm thinking of in Missouri voters chose to pass a sick leave law and increases to the minimum wage. Those have been clawed back a bit. The minimum wage, there's going to be a new minimum wage, not July 1st, I believe January 1st of 2026, but there were also um, additional increases set to go into effect in 2027, 2028, based on a certain formula. Those have been clawed back. So the states themselves can, within their own legislative operations, change these laws that they previously had passed. Okay, I think we've gone through a good number of questions. Thank you so much for those questions, and thank you so much for attending. We really appreciate it, and we hope to see you soon. Thank you.